wrongful act because of their relationship as principal as agent. The principal will be liable for that wrongful act. So it is called, in such case, they are to be treated as joint tortfeasors. Tortfeasor means who commits the tort. He is called tortfeasor. In such case, they are the joint tortfeasors, and they are liable jointly and severally to the plaintiff. Suppose similarly, when a partner commits a tort, the other partner is liable. Why? In a partnership business, all the partners, there is a relationship, the principal and agency. The other partner is the agent of the partner. All the partners are agent and principal to one another. What it says? Suppose all the partnership firm, because they are in the ordinary course of the firm, all the partners are vicariously liable for the same. All the partnership firm are liable for the guilty partner, and others are considered to be the joint feasors. Then other partners are to be joint feasors. They are also jointly and severally liable. The third situation is the same rule applies in case of master or servant, because there is relationship. First, there must be some relationship and the act connected with that relationship. So here, liability of the master arises when the servant commits a tort during the course of his employment as a servant. So now let us discuss all such things separately. How far the principal is liable for the act of agent. So where a person authorizes another to commit a tort, the liability for that will be not only of the person who commits it, the liability is also of the person who has authorized that person to do it. What is that? The Latin term is, Latin maxim, qui facit per alium facit per se. Qui facit per alium facit per se. Qui facit per alium facit per se. That means he who does an act to another, it is to be treated that as if he is doing that act. It is based on the general principle, that is principal agent, qui facit per alium facit per se. That is, which means that the act of an agent is the act of the principal. Qui facit per alium facit per se. This Latin maxim says that it is the act of the agent is the act of the principal. He who does an act to another, it is to be treated as if he has done that act. For any act authorized by the principal and done by the agent, both of them are liable jointly and severally. In this case, Leard versus Grace, Smith and Company is the leading case. What he says, that in this case, that the plaintiff, the authority to do the act may be expressed or implied. So that authority, principal must have given authority to do that act by the agent, either express authority or implied authority. The principal generally does not expressly ask his agent. The principal never asks the agent to do an unlawful act or wrongful act. But when the agent acts in the ordinary course of the performance, when the ordinary course of the performance, if the agent does an act while discharging his duties as an agent, and that is a tortious act, then the principal becomes liable for the same. The leading case is Leard versus Grace, Smith and Co. In this case, Mistress Leard had 2 cottages, but that was not giving good income. So one of the clerk of that Grace, Smith and Company, he approached Mistress Leard, that he was the managing clerk of the company. He approached Mr. Leard to what happens? Advise her to sell the 2 cottages and invest money in a better way. one of the clerk of that Smith and Company, he advised Mistress Lear to sell those two cottages, and to invest the money in a better way so that she will get good income. But what happened? That clerk, what he did, he took some documents and took signature of that Mistress Lear on some documents and converted those documents into gift deed of those cottages in his favor. So here, then the document got signed where gift were supposed to saying that supposed to be sold it, but those documents were gift deeds in the favor of that clerk in respect of those two cottages. So here the principal had he had acted solely for the personal benefit and without the knowledge of the principal. It was raised, this was pleaded, that the concerned clerk did that act for his own benefit, not for the benefit of the principal. It was held that since the agent was acting in the course of his apparent or ostensible authority, the principal was liable for the fraud. Here it was held that since the agent acted in the course of his employment of the principal in course of his engagement contract, subsisting of contract as a agent with the knowledge of the without the knowledge of the principal, apparently and ostensibly authority of the principal, then the principal was made liable. In another case, in India case, the State Bank of India versus Syamadevi, in this case, the plaintiff's husband gave some amount and checks to his friend who was an employee in the defendant bank for being deposited in the plaintiff's account. That the plaintiff's husband gave a check for deposit in the plaintiff's account. No proper receipt for the deposit was obtained. The bank employee, that was given to the bank employee, but the bank employee misappropriated the amount. It was held by the Supreme Court that the employee, when he committed the fraud, was not acting in the scope of bank's employment, but in private capacity as the depositor's friend. That is, that the employee was the depositor's friend. Therefore, the defendant bank could not be made liable for this because there was no principal and agent relationship. So, for the purpose of vicarious liability, even a friend driving my car or me as my agent will be treated as an agent. That in such case, if my friend causes an accident and kills somebody, then I am liable for that. Pay compensation for that death. In Ormond versus Crossville Motor Service Limited, the owner of a car asked his friend to drive his car. In this case, the owner of a car, Ormond versus Crossville Motor Services. The owner of the car that requested his friend to drive the car collided and killed a person with a bus. The owner of the car was held liable as he will be treated as agent. He was doing this work on behalf of him. So Lord Daring observed, the law puts on special responsibility on the owner of a vehicle who allows it to go on road in charge of someone else. Suppose I allowed my friend to drive my car. He causes an accident, he kills somebody, then I am liable. Because I have a special responsibility as the owner of the vehicle not to allow an unauthorized person to drive that car. When I allow another person to drive that car, he acts on my behalf as my agent, though he is not my servant. It is being used wholly or partly on the owner's purpose. So in such case, that is used for my purpose. He is driving the car. So the owner is liable for any negligence on the part of the driver. The owner only escapes liability when he lends that car to another, hires that car, and that driver causes accident to a third person to be used for the purpose in which the owner has no interest at all. Trilok Singh versus Kailash Bhakti, it is another case In this case, the owner of the motorcycle was outside the country. In this case, it is a very interesting case. In this case, the owner of the motorcycle was outside the country. His younger brother took the motorcycle without his knowledge or permission and caused the accident. So it was held that the younger brother could not be deemed to be the agent of the owner because the motorcycle and the and not because the owner was outside the country, agent of the owner of the motorcycle, and the latter could not, in such case, the owner will not be vicariously liable. Then the second category of persons are partners. So because when the partnership business, there is relationship of principal and agent between the partners. The rule of the law of agency applies in case of the liability also. So they are to be treated as agent and principal agency relationship is there between the partners or among the partners, more than two partners. So for the tort committed by any partner in the ordinary course of the business of the firm, all other partners are also liable. What is partner? Partnership is an agreement by two or more persons. It is agreement or when two or more persons carry a business for that is profit. So that is a partnership business. So here in such partnership business, one partner is the principal of the other partner is the agent of the another. So the liability of each partner is joint and several. In such case, one of the partner commits a tort, then the other partners, they are, because relationship of partnership is there, they are under the rule of vicarious liability, they are jointly and several liable. In Hameen versus Hodgson Co., one of the two partners of the defendant firm, acting within the general scope of his authority as a partner, bribed the plaintiff's club. One of the partners bribed the plaintiff's club and induced him to make a breach of contract with his employer by divulging secrets relative to the employer's business. So it was held that both the partners of the firm were jointly and severally liable. We are liable for the wrongdoing, including breach of contract, because there is a breach. They induced one of the employees to make breach of contract and to leave that firm, the servant, that the master. Then the third category of persons is very master and servant. It is very commonly we find master and servant. When who is a master, who is a servant? You should understand. There must be a servant is a person who has upon whom the master has some control. So whether a person is a servant or not, in certain cases there is unemployment, there may be a servant. But if a servant does a wrongful act in the course of his employment, then the master is liable for it. So this is third category. The servant, of course, is also liable. Both are liable. The wrongful act of the servant is deemed to be the, when servant does some act, that is deemed to be the act of the master. Another maxim is applicable, respondent superior. Respondent superior means what? The master is in superior. So here this respondent superior means he is solvent enough to pay the damages. Second is that the rule is that who employs somebody, he must take all precaution to employ a skilled person. If he chooses an unskilled person, a person who causes a tort, for that he is liable. So the wrongful act of the servant is deemed to be the act of the master. When a wrongful act is done by the servant, that is deemed to be the act of the master. So what is that doctrine? Doctrine of liability of the master for act of the servant is based on the maxim respondent superior, which means let the principal be liable. Respondent superior means let the principal be liable. And it puts the master in the same position as if he had done the act himself. It also derives validity from the maxim. Again, that maxim, we facit per alium per se. Facit per se, which means he who does an act to another is deemed in law to do it himself. So this is master-servant relationship. For the wrong done by the servant, that the master can be made liable vicariously. If plaintiff has a choice either to bring the suit against them jointly or severally or against any one of them. So they are to be treated as joint tortfeasors. The reason for the respondent superior, what is? Let the principal be liable. Who is superior, he should be let him be liable. Seems to the better position of the master to meet the claim because of his larger pocket. Larger pocket means what? He is solvent enough to pay the damages and also ability to pass on the burden of liability through insurance. He has the ability to shift that means meet the burden through insurance. The liability arises even though the servant acted against the express instruction. Even if the against express instruction, if the servant had committed a tort, then the liability also there. The liability arises even though the servant acted against the express instruction of the. So for the now for the master-servant relationship, two conditions must be there. First, the tort was committed by the servant. Then the servant committed the tort in the course of his employment. Two things. The course of the employment. If outside the course of the employment, the servant in his personal capacity did something and committed tort, for that the master is not liable. Then let us see who is a servant, who is, in common sense, says a person who is in service of somebody is a servant. But a servant is a person who is employed by another to do work under the direction and the control of his master. You should understand. A servant is a person who is employed, that must be employed by another to do work under the direction and under the direction of the master or control of the master. As a general rule, master is liable for the torts of his servant, but is not liable for the tort of an independent contractor. Who is an independent contractor? Independent contractor means when somebody has been entrusted as a contractor to do something, some work for him, he is called independent contractor. Suppose I want to build a house. I entrusted the job to a contractor. He is required to construct that house, build that house by engaging laborers. If one of the laborers during the course of the employment he dies, for that I am not liable because my relation with that person is not as a master and servant, but he is an independent contractor. Your servant is an agent who is subject to the control and supervision of the employer. A servant means he will be treated as an agent who is subject and control of the employer. But a independent contractor is not subject to any such control. Independent contractor means he undertakes to do certain work, and regarding the manner in which the work is to be done, he will exercise his own that experience. Independent contractor is a person who undertakes to produce a given result, but so that in the actual execution of the work, he is not under the control of the person who engages him as an independent contractor. He exercises his discretion in executing the work. For an example, my car driver is my servant. But if he negligently knock down X, I will be liable for that. Suppose, but if I hire a car, hire a taxi, going to railway station, and the taxi causes an accident, so for that I am not liable because the taxi driver is not my servant. He is an independent. I undertake because the car has been hired as an independent contractor. If I hire a taxi for going to railway station and the taxi driver negligently hits X, I will not be liable towards X because that driver is not my servant but only an independent contractor. Independent contractor means who is that is entrusted to produce a given result according to so that the actual execution of the work is done. So now, liability of the employer for the act of independent contractor. As a general rule, the master is liable for the tort committed by the servant, but employer is not liable for the tort committed by independent contractor. In this case, you should know under certain leading cases, Morgan versus Incorporeal Central Council. The plaintiff, while he was on lawful visit to the defendant premises, fell down from an open lift, sat and got injured. Suppose, for an example, a X had gone to a particular flat and used a lift, and because of some defect in the lift, he sustained injury. For that, what will happen? If this lift has been entrusted to an independent contractor to operate, in such case, the person, the owner of that building will not be liable. In this case, the same thing happens. Defendant had entrusted the job of keeping the lift safe and in proper order to certain independent contractors. So it was held that for the act of negligence on the part of the independent contractor in not keeping the lift in proper condition, the defendant will not be liable. Similarly, liability of vehicle owners. Sometimes there are many cases of accident caused by you. It is a common thing. Many cases. Suppose I have given my car for service or for repair. The garage owner used the car and caused an accident. Whether I will be made liable or the garage owner will be made liable. There are a number of cases, leading cases on the matter. There are many cases of accident caused by mechanics, repairers, or owners of workshop during test drive. Many cases. While test drive, the mechanic causes the accident, or the garage owner causes the accident, or the workshop owner causes accident, repairer. So in such case, whether the owner of that car will be liable. There is an interesting decision of Bombay High Court in Ramu Tularam versus Amichan. You should know it. But in B. Govindaraju versus MLA Govinda Raja Mudaliar, what it says, after a motor lorry was entrusted by its owner for repair, a motor lorry was entrusted by its owner for repair. While an employee of the repairer workshop drove it, there was an accident. It was held by Madras High Court that for this accident, the owner was not liable vicariously because the owner of the workshop was an independent contractor. That is this Madras High Court decision. But again, in Devendra Singh versus Mangal Singh, the Punjab and Haryana High Court held that in this case, Devendra Singh entrusted truck for repair to a workshop. While the truck was being driven by the owner of the workshop, there was an accident, which resulted in injury of a cyclist. Mangal Singh, in an action by the injured cyclist against the owner of the truck, it was held that the owner of the workshop was an independent contractor and not liable. But the trend of the recent decision of various high courts is to allow compensation to the accident victims against the owner of the vehicle. Now that is the trend. The different high courts, they have decided for giving compensation, directing the owner of the vehicle to pay it, because through him the insurance company, the vehicle is insured, vehicle is insured, the owner is making the owner liable, and through the making the owner liable, asking the insurance company to pay the compensation. The aspect of relationship independent contractor and employer between the mechanic and the workshop and the owner of the vehicle has been generally ignored. This is ignored in most of the cases that the vehicle had been entrusted to a garage owner and he used it as an independent contractor but not liable. But in this case, the Honorable Bombay High Court in Ramu versus Tularam versus Amichan have held, when the car is given to the garage for repair, the control of the car certainly transferred to the owner of the garage. That was interpreted in this manner. When a car was entrusted to the garage owner for repair, the ownership, for the time being, the control of the car was transferred to the garage owner. But the point is that in such a case, the owner of the garage is constituted by the owner of the car as his agent. So this was interpreted, thereby the garage owner became the agent. Everything done or omitted to be done by the agent, even the agent personal dosing or through his employer dosing, then the principal, that is car owner, was treated as principal and he will be made vicariously liable. This was interpreted in by Honorable Bombay High Court in Ramu Tolaram versus Amichan. What? When a car was given or a vehicle was given to the garage owner or to the mechanic for repair, the control of the car was transferred for the time being to that person. So if he will be treated as agent and the owner will be treated as principal. So if that garage owner or any of his mechanic causes an accident and thereby commits a tort, for that, they, as a agent, first the garage owner being the agent did that act, and for that the car owner being the principal is liable for the same. So what is when the what is it is that is the author, this principle is also not free from this criticism. So because making the garage owner as agent, the many high courts that directed for payment of this compensation. Now you should know what is exceptions to this. What is the exception to this? What is that? The general that an employer is not liable for the acts of an independent contractor. This is rule. As I discussed earlier, that making when the vehicle is entrusted to a garage owner, this Bombay High Court interpreted that the garage owner, the owner control over the car was transferred to the garage owner. Thereby, he became the agent of the owner of the car. And if, as an agent, he did some committed tort either personally or through by his employer, the principal will be made liable. Ultimately, if the car is the insurance car, insurance company was made liable. There are exceptions. What are those exceptions? The general that an employer is not liable for the acts of an independent contractor is subject to some exception. What are first? If an employer authorizes the doing of an illegal act, suppose the employer authorizes the doing of an illegal act or subsequently ratify that act. If an illegal act has been authorized to commit by the independent contractor, or if the independent contractor did some act and thereby that was ratified, so in such case, the employer will be liable. The real reason for such liability is that the employer himself is a party to the wrongful act. Why? The employer himself had engaged an independent contractor to do one wrongful act. In such a case, he will himself be a party to the wrongful act along with the independent contractor. And therefore, he is liable as joint tortfeasor. Second exception, an employer is liable for the act of an independent contractor in case of strict liability. That is Ryland versus Fletcher case. When there is a strict liability, an employer is liable for the act of an independent contractor in case of strict liability. What is that? Ryland versus Fletcher. When the question comes, what is strict liability? You should always remember that is Ryland versus Fletcher case. What is case Ryland versus Fletcher case? That is reservoir case. Reservoir case. The employer could not escape the liability for damages caused to the plaintiff when the escape water from a reservoir. There may be reservoir which was got constructed by independent contractor. And reservoir was constructed by an independent contractor. But there was some percolation, that is, shaft was there, defective construction. During heavy rain, this reservoir, the embankment of the reservoir breached and flooded the nearby coal frame. He was made liable. So here, under this Ryland versus principle, when there is a strict liability, in spite of the fact that the act had been done by the independent contractor, that tort was committed by independent contractor, then the person who has engaged that independent contractor will be made liable. Similar is the position in the case of extra hazardous work, which has been entrusted to an independent contractor. Extra hazardous work, suppose gas leak, that is very recently what happened in Bhubaneswar, that is leaking of explosion in the petrol pump. So in this case, the act is extra hazardous work which has been entrusted to an independent contractor. And in a case of breach of statutory duty, when there is a breach of statutory duty, in Mangan Bhai versus Ishwar Bhai, the chief trustee of the property, in this case the chief trustee of the temple, He is engaged an independent contractor to take unauthorized electricity. While taking unauthorized electricity, there was a injury, somebody sustained injury or got injured by electric current. It was held that the trustee who got the hazardous zone as well as the owner of the field from whose meter and with whose knowledge such connection was taken were liable, though independent contractor had been engaged. Similarly, liability of the employer also arises for the dangers caused by or near the highway. In case of highway, in Tari versus Astor, the plaintiff was injured by the fall of a lamp overhanging the footway adjoining the defendant's house. The lamp was attached to his house by an defendant through some independent contractor. It was held that it was the defendant's duty to that the lamp was reasonably safe. Suppose electricity department can say that I had engaged this independent contractor to take the electric line. If there is any fault, I am not liable. No, this is because it is employer arises from danger caused by near the highway or hazardous work. If the wrong caused to the plaintiff is nuisance in the form of withdrawal of support, suppose withdrawal from support for neighbor's land, independent contractor is again, the defendant would be liable, irrespective of the fact that the act causing the said damage was done by independent contractor. Third is that when the tort results in the breach of master's common law duties to his servant, he would be liable for the same, and it is no defense that the master was acting under an independent contractor. Sometimes the servant is not under the control of the master, but the servant is hired. In this case, generally, servant always remains under the control of the master. But in such case, the master is liable. But there may be a situation when the servant does not remain under the control of the master. Say, for example, a captain of a ship. He is never under the control of a master. Suppose doctors employed in that is a nursing home. There, the nursing home owner is the owner, but he is not. The doctor is not under the control of the nursing home. But the trained or modern authority is to bring into category of servants even those persons who are not subject to any such control. The recent trend is that in such case, though that some servants are not under the direct control of the master, but they are to be treated for their act, for the tort committed by them, the master-servant relationship is there and they will be liable. Because the trade of modern authority to apply hire and fire test. What is hire and fire test? That means a person who employs another person and is his paymaster and is the power to fire. Hire and fire test means he who pays the salary and he who dismisses, removes from it the job. Then that will be, he may not be in the control. The servant may not be in the control of the master. Then in such case, then will master and servant relationship. Hire and fire test. What is hire and fire test? He who pays the salary and you can dismiss him from the, or remove him from this, or discharge him from the service. That is hire and fire test. It is only the control test which was to be applied in every case. So only the control test will not be. It is only the control test which was to be applied in every case. Then if control test is applied in every case, then in most of the cases, a person will not be deprived of to get compensation on this. For an example, suppose a state-owned hospital cannot be regarded as a servant of the state. Consequently, the state cannot be held liable for the tort committed by doctor because the state has no control over the skill of the doctor. Similarly, that is in municipal corporation, so some engineer is engaged in the municipal corporation. There is a tort committed by the engineer. Then the municipal corporation will not be made liable because he has no control. No, this is the trade as says that is hire and fire test if applicable, who pays the salary and who can remove it. So in such case, there is master and servant relationship and the master is liable to pay compensation. In very interesting case, Rajasthan State Road Transport Corporation when Ken Kothari, in this case, the Rajasthan State Road Transport hired a bus and a driver for running a bus on a specific route. Had a private bus from an independent contractor for running on a specific route. the Rajasthan State Road Transport engaged a conductor. Conductor was engaged, who managed the bus, collected fare from passengers, and also exercised control over the driver. It was held that for an accident caused by the driver, the hirer, that is Rajasthan State Road Transport Corp, was vicarious liability, notwithstanding the fact that the driver continued to be in payroll of the original owner. That is because it is a very liberal approach is there. So no file, that is Workman Compensation Act, Motor Vehicle Act, we find provision that is in Motor Vehicle Act, there is a no fault liability. What it says? So on the establishment of motor accident claim tribunals under the Motor Vehicle Act, the victim of a motor accident has a right to apply for compensation in terms of section 166 of the Act. 160 is General Compensation Tribunal. So the jurisdiction of the civil court is thereby barred. That is ousted. That is out of motor accident stands ousted by section 175 Act. Until the establishment of tribunal, the claim are to be enforced through the civil court till then. So, but that is under the motor accident claim tribunal is taken away by section 167 of the Act. That section provides that the death or bodily injury arising out of motor accident, which may also give rise to a claim of compensation under the Workman Compensation Act, when there is an accident under the motor vehicle accident, when that also an action can be brought under the Workman Compensation Act, then the victim has an option either to choose either of the forum, either under the before the motor accident criminal or under the Workman Compensation Act. So here, by this conferring the claim or authority of tribunal under either of the acts, the legislature incorporated the concept of election. This is a concept of election. When workman, suppose a conductor died while in an accident, due to an accident, he is a workman. He can choose to get compensation from the employer under the Workman Compensation Act, or he may claim compensation under the law of tort in the motor vehicle, that is tribunal, the motor accident tribunal. So, claim tribunal. So here, this is very important. Hospital case, in the Honorable Supreme Court in National Insurance Company versus Mustang, going by the principal election that has been upheld, that on the language of section 167 of the Motor Act, going by the principle of election of remedies, a claimant opting to proceed on the Workman Compensation cannot take recourse to the Motor Vehicle Act. Once the claimant took the recourse of the getting compensation under the Workman Compensation Act, he cannot later file case make claim under the Motor Vehicle Act, Motor Vehicle Act. Hospital case, the hospital authorities were held not to be vicariously liable for the negligence of the professional staff involving professional care and skill because they lacked power. That position is no more holdable because the hospital authorities are now made liable. There are number of cases. In Kasidi, Ministry of Health, the hospital authorities were held liable when due to negligence of the house surgeon and other staff during post-operation treatment, the plaintiff hand was rendered useless. So the hospital cannot take the plea that he has no authority, control over the surgeon. Similarly, sometimes a servant is lent, when A lends his servant to X to B and X commits a tort against C, then the question is who is to be made liable. Suppose I have a servant. I lent my servant to my friend. And when that servant is working under my friend, he commits a tort. Whether for that my friend will be liable or I will be liable. So in this case, the answer to this question depends upon the various considerations. The main considerations being as to who of the two masters has the authority. Who of the two masters has the authority to tell the servant not only what is to be done by him, but the way in which it is to be done. In Mercy Duck Harbour Board versus Coggins, a Griffin's case, a harbour board owned a number of mobile cranes and an employed skilled workmen as the drivers of the cranes. It was usual for the board to let out the mobile cranes. Each driver is driven by the skilled driver employed by them. Certain stevedores had a crane together with a driver for loading ship. Due to the negligence of the driver while loading a ship, X was injured. The House of Lords held that the harbour board who was the general and permanent employer of the driver was liable. General. If the steward were not liable, even though at the time of negligence the driver was loading cargo for the stevedores. Say similar question had arisen before the Punjab High Court in Kundan Kaur versus Shankar Singh. In this case, Shankar Singh and Tarlok Singh, the partner of a firm, temporarily gave their truck along with a driver on hire to one Jowar transport. One person temporarily gave his truck to another person for transporting certain goods from one place to another. While the goods were being transported, Kundanlal Kohli, an employee of Jawaharlal Transport Company, seated himself by the side of the driver. As a result of rash and negligence of the driver driving, the vehicle met with an accident and Kundanlal means to whom the truck had been given on hire, who was sitting by the side of the driver, he was killed. The question in this case arose, could Shankar Singh and Tarok Singh, both who had hired the truck, that means who had given, not hired, who had given the driver and truck on hire, be liable to Srimati Kundan Kaur, the widow of the deceased? In this case also, the High Court was of the view that there was only a transfer of service and not a control of the driver. There the Honorable Court held only a transfer of this, not of the control of the driver from the general employer to the hirer of the vehicle. And as such, Shankar Singh and Trilok Singh were liable for this. This is very interesting case. Even transport employee for that must be, this is. The third is, there must be a course of employment. During the course of, a master like a principal is liable for every tort which actually authorizes. The liability of master is not limited to the act which is expressly authorized to be done, but he is also liable for any act, even if an unauthorized act committed by during the course of the employment. So during the course of employment, so we have wrongful act authorized by the master, a wrongful and unauthorized mode of doing some act authorized master. This is very important. The course of the employment is very important. So what is that? So a master can be made liable as much as unauthorized act. Even unauthorized act, they suppose a servant is there. A servant, a driver. He took the vehicle to the petrol pump for filling the petrol. There also, if he unauthorized uses that car and went to his house and thereby he causes an accident, then for that the master, the owner of the vehicle is liable as the master. Fraud of servant, similarly, when a servant while in the course of performance of his duty as such commits a fraud, the master will be liable for the same because respondent superior, that is solvent enough to pay the compensation. Second, he must choose a better employee. It is a settled and undisputed principle of law of torts that the master is answerable for every such wrong of his servant as is committed in the course of service. Though no express command or privity of master be proved, though this is very, very important things. This is master servant debate. Even a theft by servant. Suppose servant commits a theft. What will happen? In Chazier versus Bailey case, it was held that if the servant committed a theft of a third person property which had been billed to the master, then the master could not be vicariously made liable for the same because the servant's act of committing theft is outside the employment, is not during the course of the employment, considered to be outside the course of employment. This is this was overruled in the year 1965. In this case, the defendants were the belly of a fur coat given to them for cleaning. They gave this coat to the servant, Moristry, for claiming Moristry stole the coat instead of cleaning the same. It was held by the Court of Appeal that the act of the servant in stealing the coat to whom the same had been entrusted for cleaning was a wrongful act, illegal act done by the course of the employment and is liable. So, theft was not billed to the master. In Ruplal versus Union of India, in this case, the question which had arisen before the Jammu and Kashmir High Court was regarding the liability of the master for the theft committed by his servant of the plaintiff's property, which had not been billed to the master. Suppose the property had not been billed to the master, the servant committed theft of the property of another. So in such case, the master will not be liable. In that case, some military jawans who are in the employment of the central government lifted some firewood belonging to the plaintiff and carried the same away in military vehicle for the purpose of campfire and fuel. The question arose whether the act of the Jawans could be considered to be in the course of employment as to make the Union of India liable for the same. It was held that the act of the Jawans fell within the course of employment and the Union of India was liable for the same in this case. Even the learned judge has held that the Jawans are supposed to be on duty on all 24 hours. Obviously, if they were and are supposed to be on duty all 24 hours, and if they lifted the firewood belonging to the plaintiff, and that too in the army vehicle, that action of theirs would be the course of employment. Similarly, mistake of servant, where a servant having a lawful authority to do some act on behalf of the master makes any erroneous exercise use of the authority, causing loss to the plaintiff, the master will be liable for the same. It will be mistake. So this is master servant. Even for the negligence of the servant, the master will also be liable. So when the act is outside the course of the employment, in such case the master will be liable. When a servant does an act which is not in the course of the employment or business, the same is due to the outside course of employment. It may be a course of employment even though that is not strictly in the performance of the duties. It is very important. You should understand what is course of employment, what is outside the course of employment. So let us conclude. In the next class, we will discuss the remaining. Thank you.